My name is Nora Callahan. I'm 34 years old, and on a Tuesday afternoon in October, a probate court judge in Fairmont County read a document into the record that my parents had spent 2 years insisting did not exist. 6 weeks after my father's funeral, my mother sat across from me at her kitchen table and said, "The inheritance was never meant for you, Nora. You need to make your peace with that." I did make my peace with it, just not the way she expected. Because 11 months later, a retired attorney my father had trusted 40 years earlier handed me an envelope that changed the entire math of what meant for you actually meant. A document worth $1.2 million that my family had spent a small fortune trying to make sure I never saw. This is the story of how I found it. My father, Frank Callahan, started Callahan Precision Tool and Die in 1987 with a bank loan, a rented warehouse bay, and 2 second-hand lathes he'd bought at auction from a shop that had gone under. By the time I was in high school, it employed 41 people and supplied precision components to 3 different aerospace subcontractors. It was, by any measure, the thing my father had built his entire identity around, and it shaped the entire architecture of our family in ways I didn't fully understand until I was an adult. My older brother, Wade, was groomed for the business almost from birth. He started sweeping floors in the shop at 14, ran a CNC machine by 16, and by the time he graduated from the state university with a business degree, everyone, my father, my mother, the shop foreman, the family friends who'd known us for decades, understood that Wade was the heir apparent. Nobody used that word out loud, not at first, they didn't have to. It was simply understood, the way weather is understood, as a fact of the environment rather than a decision anyone had actively made. I went a different direction. I loved teaching from the time I was in middle school, tutoring younger kids in math before I fully understood it was something you could do for a living. I got my education degree, took a position teaching 4th grade at a public elementary school 20 minutes from where I'd grown up, and built a life that had nothing to do with tool paths or aerospace tolerances. My father never once made me feel small for that choice. If anything, he seemed almost relieved that at least one of his children wanted a life outside the shop's orbit. My mother was harder to read. Louise Callahan had spent 30 years as the company's informal social architect, the woman who organized the Christmas party and remembered every employee's spouse's name. And I think, in her own quiet way, she'd always measured her children's worth partly by their proximity to the business. Wade had proximity, I had distance. That distance became, over the years, a kind of quiet current running under every family gathering. Never spoken aloud, but always present, the way a draft moves through a house, no matter how many doors you close. There had been, over the years, specific promises made to me, not about the business itself, which I never wanted any part of, but about a separate piece of the family's finances. A trust my father had established when I was in my 20s, funded by proceeds from the sale of my grandmother's farm, which had passed to my father when she died. My father had told me directly more than once over the years, at my college graduation, at my wedding, at a dinner the year my son was born, that this trust was yours, separate from the business, no matter what happens with the shop. I have a card he wrote me on my 30th birthday, which I still have, that reads, in part, "Wade gets the shop because he built his life around it. You get your grandmother's legacy because you built yours around something better." I didn't think much about the legal mechanics of any of this at the time. I trusted my father's word, the way you trust a parent's word when you've never had a specific reason not to. I should say something here about my grandmother, because the trust wasn't an abstraction to me. It was tied to a person I loved. My grandmother, Eleanor, had run a small dairy farm for 40 years after my grandfather died young, refusing every suggestion from relatives that she sell and move into town. My father had been adamant that this particular money not simply get absorbed into the business's operating capital. "Your grandmother didn't work herself half to death so it could go buy a new stamping press," he told me once, only half joking. He wanted it kept separate, growing quietly on its own, meant eventually for me. My father was diagnosed with pancreatic cancer in February 2022. He was given, at diagnosis, somewhere between 6 and 14 months, depending on how his body responded to treatment. He chose an aggressive treatment protocol initially then, after a difficult first round of chemotherapy, left him weaker than any of us had prepared for, shifted toward comfort-focused care in the final months. Wade, understandably, absorbed more and more of the day-to-day operations of the business during this period. Someone had to, and I was 2 hours away with a full-time teaching job and a 5-year-old son, unable to step into daily shop operations even if anyone had asked me to, which no one did. What I didn't fully register during those months of watching my father decline was how much unsupervised access Wade, and, by extension, my mother, who leaned on Wade heavily for every decision once my father's mind began to fog under pain medication, had to the business's legal and financial infrastructure during that same window. I was focused on driving down every weekend I could manage, sitting with my father while he was lucid enough to talk, helping my mother with meals and medication schedules. I was not at the time thinking about estate documents. I had no reason to. My father had told me as recently as that Christmas that everything was handled the way we've always talked about it. I believed him. I had never had a reason not to. My father died on March 3rd, 2023, at home with my mother, Wade, and me in the room. He was 69 years old. I remember, in the days immediately after, feeling grateful at least, that the three of us had been together at the end, that whatever tensions existed under the surface of our family had not prevented us from standing at his bedside as one unit in his final hours. I would spend the following 2 years learning that being present in a room together and being honest with one another were not, in fact, the same thing, but I didn't know that yet, not on March 3rd. On March 3rd, I only knew that my father was gone and that I had lost him. The reading of the will took place 3 weeks after the funeral, in the office of Gerald Voss, the attorney who had handled the Callahan family's business and personal legal affairs for as long as I could remember. I'd known Gerald my whole life. He'd attended my wedding, sent a gift when my son was born, sat 2 pews behind us at the funeral. I had no reason to walk into that meeting with anything but grief, and the assumption that whatever my father had arranged would reflect what he'd always told me. Gerald slid a document across the desk, a will dated November 14th, 2022, 4 months before my father's death. During a stretch I now know coincided with one of the heaviest periods of his pain medication regimen. He read through it in the flat, procedural tone attorneys use for documents like this, and the relevant language landed somewhere in the second page. I give, devise, and bequeath all shares of Callahan Precision Tool and Die LLC, together with all real property associated with the business premises, to my son, Wade Francis Callahan. I give, devise, and bequeath the remainder of my estate, including any trusts previously established, to my son, Wade Francis Callahan, to be administered at his discretion for the benefit of my daughter, Nora Callahan Rise, as he deems appropriate. I remember the specific silence that followed those words. Not shock exactly, shock came a few seconds later. In that first moment, it was something closer to disbelief. The sensation of hearing a sentence in your native language and not being able to process its meaning anyway. The trust, I said. My grandmother's trust. Dad told me that was separate. He told me that for years. Gerald didn't quite meet my eyes. This will supersedes any prior arrangements, Nora. It's dated November of last year. It's his most recent expressed wishes. At his discretion, I repeated, looking at Wade. What does that mean exactly? Wade, to his credit, at least had the decency to look uncomfortable. It means I'll take care of you, Nora, obviously. Nothing's going to change with us. That's not what it says, I said. It says you decide. It doesn't say I'm entitled to anything. It says you get to decide what I'm entitled to. My mother spoke then, in the same even, faintly weary tone she'd used to settle an argument between Wade and me when we were children. Your father knew what he was doing, Nora. The business needed to stay whole. You know that. Wade spent his whole life in that shop. And I've spent my whole life being told the trust was mine regardless, I said. Separate from the business. That's what he told me at my wedding. That's what he wrote me on a birthday card I still have in a drawer at home. People say a lot of things over the years, my mother said. What matters is what's legally written down. And what's legally written down says, the inheritance was never meant for you the way you're thinking of it, Nora. It was meant for the business. For Wade. You need to make your peace with that. I left Gerald's office that day with a copy of the will, a growing knot of nausea, and a question I couldn't shake. My father had told me, explicitly, as recently as that Christmas, 6 weeks before this document's signing date, that everything with the trust was handled the way we've always talked about it. Either he had changed his mind entirely in the 6 weeks between that conversation and November 14th, during a period when his oncologist's own notes, which I would later obtain, described him as experiencing moderate to severe cognitive fog secondary to opioid-induced dosage adjustments, or something else had happened in that room the day this document was signed. I called Wade that evening, still shaking, hoping for some version of the conversation that would make sense of what I'd just heard. He picked up on the second ring, his voice carefully even, the voice he'd always used at the shop when he was managing a difficult customer. "I know how this looks," he said. "Dad worried about the business surviving if got split up. He worried about you having to deal with any of that stress. He never once told me the trust and the business were connected," I said. "Not once in 15 years. People change their minds when they're facing the end, Nora," Wade said. "You weren't there for a lot of those conversations." I was. That sentence stayed with me longer than almost anything else said that week. You weren't there. It was true, in the narrowest sense. I had a job and a family 2 hours away, and Wade had been down the hall from our father's bedroom for months. But it also carried an implication I couldn't shake. That presence alone was being treated as evidence of intent, as though proximity to a dying man's bedside automatically translated into knowledge of his uncoerced wishes. I didn't have proof of anything yet. I had a feeling, the kind of feeling I'd trained myself, as a teacher who spent a career reading kids' faces, for the difference between a real excuse and a rehearsed one not to dismiss. I decided to find out what had actually happened. I want to be honest about how this started, because it wasn't with a lawsuit. It started with a phone call to a woman named Denise Okafor, an estate litigation attorney a colleague at my school had used during her own father's contested probate 2 years earlier. I called her in April 2023, less than a month after the will reading, more to understand my options than because I'd decided to fight anything. "Tell me everything you remember about the 6 months before your father's death," Denise said in our first call. Dates, who was present, who wasn't, any conversations about his estate plans that you can recall specifically. I spent that entire evening writing a timeline by hand at my kitchen table after my son went to bed. Every visit I remembered, every conversation about the trust, every date I could reconstruct from my calendar, and my texts with my mother and Wade. Denise reviewed it 2 days later and told me something that reoriented the entire way I understood what I was dealing with. "This isn't necessarily about proving your father didn't love you the way he said he did," she told me. "It's about establishing whether the document signed on November 14th, 2022, reflects his genuine, competent intent, or whether it reflects undue influence exerted on him during a period of documented cognitive impairment. Those are two very different legal questions, and only one of them requires proving anything about your family's character." I retained Denise formally on April 19th, 2023. I want to be clear about what that decision cost, because none of this happened without real sacrifice. Denise's retainer was $7,500, which I paid by draining almost the entire emergency fund my husband Marcus and I had built over 6 years of careful saving. Contesting a will in Fairmont County, Denise told me plainly, could run anywhere from $15,000 to $60,000 depending on how far it went, with no guarantee of recovery even if I won, since Fairmont County didn't have a fee-shifting statute that would require the estate to cover my costs automatically. Marcus and I had a long conversation at our kitchen table that night about what we were willing to risk. We agreed to proceed, but with hard limits. We would not touch our son's college fund, and we would revisit the decision every 6 months based on where the case actually stood. There were months over the following year when the financial pressure of this decision felt almost as heavy as the grief itself. I picked up a summer tutoring contract in June 2023 specifically to cover a second invoice from Denise's office that fall. Marcus took on weekend shifts at the hardware store where he'd worked in his 20s. Something neither of us had planned to need again at this stage of our lives. We canceled a family trip we'd been saving toward for 2 years. None of it was dramatic, exactly, no single moment where everything collapsed, but it was a slow, cumulative tightening, month after month, of a life that had been comfortable becoming a life that required careful arithmetic every time a bill came due. I remember sitting at our kitchen table in September 2023, looking at a legal invoice for $3,200 and thinking, not for the first time, that it would be so much easier to simply let this go, to accept whatever version of at his discretion Wade was willing to offer, and move on with my life. I didn't, and I've thought a great deal since about why not. Part of it was principle. Part of it, I think, was simply refusing to let a room full of people decide, on my behalf, what my father had actually meant. I also want to be honest that not everyone in my extended family supported the decision to fight this in court. My Aunt Peggy, while sympathetic, told me more than once that she worried I was spending money I might never see again, chasing a version of Dad that might not have existed the way I remembered it. A cousin I'd been close with, growing up, stopped responding to texts for the better part of a year, apparently deciding that contesting a will was an act of greed rather than an act of seeking the truth. The first 6 months were slow, methodical, and almost entirely invisible to my family. Denise filed a formal will contest in Fairmont County Probate Court on May 8, 2023, alleging lack of testamentary capacity and undue influence, which under the court's own procedural timeline meant discovery. The formal exchange of documents and information would take a minimum of 4 to 6 months before anything resembling a hearing date could even be scheduled. During discovery, 3 things surfaced that mattered enormously. The first was my father's complete oncology records from Fairmont Regional Cancer Center, obtained through a formal medical records subpoena in June 2023. Buried in the chart notes from a visit dated November 9, 2022, 5 days before the will was signed, his oncologist, Dr. Priya Ramaswamy, had written, "Patient reports increased fatigue and intermittent confusion, particularly in afternoon hours. Discussed adjusting oxycodone dosing schedule. Patient's wife present for visit and confirmed similar observations at home." My mother had been in that exact appointment 5 days before the will's signing and had personally confirmed to my father's own oncologist that he was experiencing intermittent confusion. She had never once mentioned this to me. The second was the notary log from the office where the will had been executed, not Gerald Voss's own office, as I'd initially assumed, but a small notary and shipping storefront 20 minutes outside of town, a detail that struck Denise as immediately unusual. Estate attorneys almost always execute documents like this in their own office, with their own staff as witnesses, she told me. Using an outside notary is not illegal, but it's unusual enough to ask why. When Denise deposed the notary, a woman named Sandra Kiplin, in August 2023, Sandra testified that she had no independent memory of the specific signing. She notarized dozens of documents weekly, but her log confirmed the witnesses present that day were Wade Callahan and a Callahan Precision Tool and Die employee named Russ Delgado, both of whom had a direct financial interest in the will's contents, which, while not automatically disqualifying under state law, was, in Denise's words, not how you'd do this if you wanted it to be unimpeachable. Denise also flagged something in Gerald Voss's own billing records from that period, produced during discovery under a document subpoena, an entry dated November 12, 2022, 2 days before the signing, for drafting per client instructions relayed by W. Callahan, rather than the more typical language Gerald used elsewhere in his files, per consultation with F. Callahan. It was a small distinction, easy to miss, but Denise circled it in red the moment she found it. "This is the closest thing to a paper trail you'll ever get showing who was actually driving the instructions on this document," she told me. "It wasn't your father calling Gerald's office. It was your brother." The third discovery, and the one that changed the entire trajectory of the case, came almost by accident. In September 2023, while reviewing Gerald Voss's own file production, the physical and electronic records his office was required to turn over regarding any prior estate planning work for my father, Denise noticed a billing entry from nearly a decade earlier, in 2014, referencing trust drafting, Callahan family, per H. Whitcomb referral, a name that appeared nowhere else in Gerald's more recent files. "Do you know who Harold Whitcomb is?" Denise asked me. I didn't, not at first. It took a phone call to my mother's sister, my Aunt Peggy, who still lived in the same town my father had grown up in, to place the name. Harold Whitcomb had been my father's original attorney. decades before Gerald Voss ever entered the picture. The man who had helped my father incorporate the business in 1987, and who had, according to Aunt Peggy, handled all the Callahan family's paperwork until his retirement sometime in the early 2010s. When my father, by then dealing with a much larger and more complex business, had transitioned to Gerald Voss's firm for ongoing legal work. Harold Whitcomb was, as of September 2023, 83 years old, retired, and living 40 minutes outside of Fairmont County. Denise sent a formal letter requesting any records he might still possess related to prior Callahan family estate planning. Harold called her office directly 2 days later. "I have a file," he told her, according to the notes Denise shared with me afterward. "I kept copies of everything I ever drafted, out of habit, even after I retired. If Frank Callahan's family needs to know what he actually wanted, I still have it in my basement." I want to pause here because this is the point in the story where the parallel track of my life, the part that had nothing to do with the lawsuit, matters just as much as the legal fight itself. Throughout 2023, while Denise built this case piece by piece, I kept teaching. I kept raising my son, who turned 6 that October and started first grade with a missing front tooth and an obsession with dinosaurs that I leaned on, some nights, as the only thing capable of distracting me from the exhaustion of fighting my own family in a courtroom. In January 2024, I was asked to take on a lead teacher role for my school's new literacy intervention program, a promotion I'd worked toward for 3 years, and which I very nearly turned down that winter because I couldn't imagine having the bandwidth for anything else. Marcus talked me into accepting it. "You need something in your life right now that isn't about proving anyone wrong," he told me. He was right. That promotion, and the small, steady satisfaction of watching second graders finally crack the code of reading fluency, kept me tethered to a version of myself that had nothing to do with wills or probate court, and I am convinced, looking back, that it was part of what let me stay steady enough to keep fighting the rest of it. There is a specific memory from that winter I still return to. It was a Tuesday afternoon in late January, a few weeks after I'd accepted the literacy program role, and one of my students, a quiet boy named Theo, who'd struggled with reading fluency since September, finally read an entire passage out loud without stumbling, for the first time all year. He looked up at me afterward, grinning, proud of himself in a way that had nothing to do with anyone's approval but his own. I remember standing in that classroom, thinking about my father's estate documents sitting in a folder on my kitchen table at home, and feeling, for just a moment, entirely separate from all of it. I drove out to see Harold Whitcomb myself in October 2023, with Denise's blessing, though she came with me for the meeting itself, both of us sitting at Harold's kitchen table while he pulled a thick manila folder from a filing cabinet in his basement that hadn't been touched, by his own account, in almost a decade. Inside was a will dated April 3, 2014, 9 years before my father's death, properly executed in Harold's own office, witnessed by Harold's longtime paralegal and a second independent witness, both with no financial interest in the estate, and notarized by a notary public whose license Denise later confirmed was in good standing at the time. The 2014 will divided my father's estate differently than the 2022 document Gerald Voss had presented at the reading. The business, Callahan Precision Tool and Die, its equipment, its real property, its ongoing operations, went to Wade exactly as everyone had always understood it would. But a separate trust, funded specifically by the proceeds of my grandmother's farm, held in a segregated account that had never been commingled with the business's finances, was designated explicitly, unambiguously for me with language that read, "This trust and all assets held within it shall pass to my daughter, Nora Callahan Wright, free and clear of any discretion by any other party, in recognition of the life she has built independent of the family business." The trust's most recent statement, which Harold still had a copy of from a routine 2014 update, valued its holdings at just under $1.2 million. A combination of the farm sale proceeds, invested over the years in a diversified account Harold had helped my father establish, and a small rental property portfolio purchased with the trust's early returns, all of it explicitly separate from the business Wade had inherited. Harold pointed out, flipping to the account statement's final page, that the growth over 9 years had come almost entirely from patient, conservative investing. Nothing dramatic. Nothing that would have drawn anyone's attention if they'd gone looking, which was, I think, exactly the point. Your father called me twice a year, every year, right up until he switched firms, Harold told me, his hands folded on the kitchen table, just to check that everything with your trust was still in order. He was very particular about that. He never once asked me to change a word of it. I sat in Harold Whitcomb's kitchen and cried for the first time in the entire 8 months since the will reading. Not out of grief exactly, though there was plenty of that mixed in, but out of something closer to vindication. The specific, physical relief of learning that the version of your father you'd trusted your whole life had, in fact, been real. Harold walked me through the rest of the file that afternoon, page by page, in the unhurried way of a man who had clearly been waiting a long time for someone to ask him these questions. There were letters, too, 3 of them, handwritten, from my father to Harold over the years, none of them long, but each one touching on the same theme. In a letter dated March 2016, shortly after my father's firm transitioned to Gerald Voss, my father had written, "Wanted you to know I'm keeping things with Nora's trust exactly as we set them up. New lawyer doesn't need to touch that part. Some things I'd rather leave with the man who actually understood why I wanted it that way." Reading that sentence, in my father's own handwriting, in a kitchen 40 minutes outside of Fairmont County, was the closest I came, in the entire 2 years of this fight, to hearing his voice again. The 2014 will had never been formally revoked. Under Fairmont County probate law, as Denise explained to me over the following weeks, a later will only supersedes an earlier one to the extent the later document is itself valid. And if the November 2022 document could be proven invalid due to lack of capacity or undue influence, the 2014 will, never revoked, would stand as my father's last valid expression of intent. We had, by late 2023, everything we needed to take this to a formal hearing. Medical records documenting cognitive impairment 5 days before the contested will signing, a notary and witness arrangement that raised serious procedural questions, and a properly executed, decade-old will that directly contradicted the terms Wade and my mother had presented as my father's final wishes. What we didn't have yet was an idea how my family would react when they found out. The hearing confrontation Denise filed formal notice of the newly discovered 2014 will with the Fairmont County Probate Court on November 30th, 2023, along with a motion requesting the court schedule an evidentiary hearing on both the will contest and the newly surfaced document. Under court procedure, opposing counsel, meaning Gerald Voss, still representing the estate on Wade and my mother's behalf, had to be formally served with the filing, which meant that sometime in the first week of December 2023, my mother and Wade learned, for the first time, that a second will existed. I did not hear from either of them directly. I heard, instead, from my Aunt Peggy, who called me on December 6th to tell me my mother had phoned her in tears, saying I was trying to tear this family apart over money my father never actually meant for me to have this much of. I heard, secondhand, that Wade had gone to Gerald Voss's office demanding to know how a will from 2014 could possibly still be valid, and that Gerald, according to Aunt Peggy's account of what she'd heard from a mutual family friend, had seemed genuinely unaware the 2014 document existed at all. He'd only represented the family since 2016, after Harold Whitcomb's retirement, and had apparently taken my mother's word, at the time the 2022 will was drafted, that no prior estate planning documents needed to be accounted for. I want to be careful here, because I don't know with certainty what Gerald did or didn't know. And Denise cautioned me repeatedly against assuming malice where negligence, or simple incomplete information, might explain just as much. What I do know is that in the 6 weeks between the filing and the scheduled hearing date, my mother called me exactly once, on December 14th, 2023. "You're going to humiliate this family in front of a judge," she said, without any preamble, when I picked up. "Over a piece of paper from a man who hasn't practiced law in 10 years. "It's a valid will, Mom," I said. "Denise has confirmed the notarization, the witnesses, everything. It was never revoked. Your father wanted the business protected," she said. "That's what mattered to him at the end, not some farm money from 30 years ago." "Then why?" I said. Did he call Harold Whitcomb twice a year for almost a decade just to confirm my trust was still exactly the way he'd set it up? Why did he tell me at my own wedding, in front of witnesses, that it was separate from the business no matter what happened? You were in the room for that conversation, Mom. You know he said it. She didn't have an answer to that. What she said instead, after a long pause, was the same sentence she'd used at Gerald's office 8 months earlier, delivered now with less certainty than it had carried the first time. The inheritance was never meant for you the way you're thinking of it, Nora. I think it was, I said. I think it was meant for exactly this. I think Dad built a system specifically so that if anything ever happened to change his mind under circumstances that weren't really his own, there'd be a version of the truth that couldn't be talked out of existence. I think that's why he kept calling Harold. I think some part of him knew. She hung up the phone before I finished. We didn't speak again before the hearing. Wade reached out once, by text, on January 9th, 2024, the week before the hearing was scheduled. His message read, "I never wanted any of this to turn into a courtroom thing. If you want to talk before this goes any further, I'm willing." I considered responding for a long time before I finally wrote back. I tried to talk about this for 8 months, Wade. Nobody wanted to talk until there was a hearing date on the calendar. He didn't respond after that. In the same period, Denise received notice that Gerald Voss had retained an outside forensic accountant to review the trust's financial history, presumably to look for any grounds to argue the trust itself had been mismanaged or diluted in some way that might reduce what I stood to recover, even if the 2014 will was upheld. It came to nothing. The trust's records, meticulously maintained by the investment firm my father had used since 2014, showed no irregularities of any kind, but it meant the 2 weeks before the hearing were not quiet ones. Denise and I spent several additional evenings reviewing 12 years of account statements line by line, making sure nothing in the forensic accountant's eventual report could catch us by surprise on the stand. I spent the 2 weeks before the hearing preparing with Denise, almost every evening after my son went to bed, reviewing the timeline of evidence until I could recite dates and document numbers without looking at my notes. Denise walked me through what to expect procedurally, that this would be an evidentiary hearing in front of Judge Miriam Alvarez, who handled contested probate matters for Fairmont County, that both sides would present evidence and call witnesses, and that the judge, not a jury, would ultimately determine both whether the 2022 will was valid and, if not, whether the 2014 will should be admitted to probate in its place. "I want you to understand something," Denise told me, the night before the hearing, in her office with the lights low and a legal pad full of her handwriting between us. "This isn't a case built on your family being bad people. It's a case built on documents and dates and a doctor's chart note. That's actually good news for you, because it means you don't have to convince anyone of anything about your mother's or your brother's character. You just have to let the paper trails speak." I held on to that the entire drive home that night, and again the next morning, putting on the one blazer I owned that felt appropriate for a courtroom, driving to the Fairmont County Courthouse with Marcus beside me, my hands steadier on the wheel than I expected them to be, given everything. My son stayed with Marcus's parents that day, old enough by then to know something important was happening, too young to understand exactly what. I remember him handing me a drawing that morning, a stick figure family under a rainbow, and telling me, with the particular solemnity 6-year-olds reserve for moments they've decided are serious, "Good luck at your meeting, Mom." I kept that drawing in my bag through the entire hearing. The hearing took place on January 16th, 2024, in Courtroom 4 of the Fairmont County Courthouse, before Judge Miriam Alvarez. My mother and Wade sat at the opposing table with Gerald Voss. I sat with Denise. It was the first time I'd seen either my mother or my brother in person since the will reading, 10 months earlier, and I remember being surprised by how ordinary the moment felt. No dramatic entrance, no confrontation in the hallway, just two families' worth of grief compressed into a room with fluorescent lighting and a court reporter typing quietly in the corner. Denise presented our case first. She introduced the 2014 will as Exhibit 12, Walking Harold Whitcomb, called as a witness, 79 years into a legal career he'd otherwise long since left behind him, through its execution. The date, April 3rd, 2014. The location, his own law office. The witnesses, his paralegal Dorothy Fenn and a second independent witness, both confirmed still living and available to testify if needed. The notary, whose license was verified active and in good standing on the date in question. Harold testified, in the same steady voice he'd used at his kitchen table, that my father had called him, at minimum twice a year, every year, from 2014 until his firm transitioned to Gerald Voss's practice in 2016, specifically to confirm the trust provisions for his daughter remained unchanged. Did Mr. Callahan ever at any point ask you to alter or revoke this document? Denise asked. Never, Harold said. Not once. On cross-examination, Gerald Voss pressed Harold on his memory, noting that nearly a decade had passed, and asking whether it was possible he was simply recalling what he wanted to remember. Harold's answer stayed with me. Mr. Voss, he said, I kept a written log of every call I had with former clients after retirement out of an old habit from 40 years of practice. I'm not testifying from memory alone. I'm testifying from my own contemporaneous notes, dated at the time each call occurred. I'd be happy to have those entered as exhibits as well if the court would find that useful. Judge Alvarez from the bench said she would. Denise, in a brief aside during a recess later that morning, told me something I've held on to since. Judges see a lot of will contests that really are just about hurt feelings dressed up as legal arguments, she said. This isn't one of those. I didn't fully understand what she meant until the ruling came down, but sitting in that hallway during the recess, I let myself believe, for the first time in almost a year, that this might actually go the way we'd built it to go. Denise then introduced the oncology records as Exhibit 15. Dr. Ramaswamy's chart note from November 9, 2022, 5 days before the contested will signing, documenting intermittent confusion and noting my mother's own presence and confirmation of the same symptoms. Dr. Ramaswamy, called by video deposition since she was unavailable to appear in person, testified that in her professional opinion, a patient experiencing the level of opioid-related cognitive fog, documented in her notes from that period, would reasonably be expected to have diminished capacity to fully understand and appreciate the terms of a complex legal document, particularly in afternoon hours, which was when the November 14th signing, per the notary's log, took place at 2:40 p.m. That single detail, the timestamp on Sandra Kiplin's notary log, cross-referenced against Dr. Ramaswamy's specific note about afternoon hour confusion was, Denise told me afterward, the moment she watched Judge Alvarez's expression change from neutral attentiveness to something more focused. Gerald Voss, for his part, argued that testamentary capacity is a legal threshold, not a medical one, that a person can have documented cognitive symptoms and still meet the legal standard of understanding the nature of their assets and the natural objects of their bounty at the specific moment of signing, and that no medical professional had directly examined my father on November 14th itself to confirm incapacity in that precise window. It was a reasonable legal argument, and Denise had prepared me for it. But it did not address the second half of our case, which Denise turned to next, undue influence. She called Sandra Kiplin, the notary, who confirmed under oath that she had no specific memory of the document, but that her log showed that the only two witnesses present were Wade Callahan and Russ Delgado, a Callahan Precision Tool and Die employee. She called Russ Delgado himself under subpoena, who testified, visibly uncomfortable. According to Denise's account, glancing repeatedly at Wade during his testimony, that Wade had asked him, the morning of November 14th, 2022, to come along and be a witness for something with Frank's paperwork, and that he had signed without reading the document in full, believing it to be routine business stuff. The gut-punch moment of the entire hearing came during Denise's cross-examination of my mother, who took the stand at Gerald's request to testify to my father's clear and consistent wishes in his final months. Mrs. Callahan, Denise asked, were you present at your husband's oncology appointment on November 9th, 2022? I was, my mother said. And is it accurate that during that appointment, you personally confirmed to Dr. Ramaswamy that you had observed intermittent confusion in your husband, particularly in the afternoons? My mother hesitated. I don't recall the exact wording. Denise held up a printed copy of the chart note. I'd like to read Dr. Ramaswamy's note into the record, Your Honor. for Mrs. Callahan's reference. Patient's wife present for visit and confirmed similar observations at home. Mrs. Callahan, do you recall telling your husband's oncologist that you had observed the same confusion he was reporting? There was a long pause before my mother answered. Yes, she said finally. I remember that conversation. And 5 days later, Denise continued. At 2:40 in the afternoon, according to the notary's own log, your husband signed a document that reversed 9 years of consistent, independently confirmed estate planning he had reaffirmed as recently as that Christmas, according to your daughter's testimony. Were you present for the signing on November 14th? I was in the building, my mother said, not in the room. But you drove him there, Denise said. Is that correct? Yes, my mother said quietly. Whose idea was the appointment, Mrs. Callahan? Yours, your son's, or your husband's? The silence that followed lasted long enough that Judge Alvarez, without being asked, said, You need to answer the question, Mrs. Callahan. It was Wade's idea, my mother said. He said it needed to be settled while there was still time. I watched my mother's face while she said this, and I did not feel triumph. I want to be honest about that, because I think it would be easy telling this story to make that moment feel like a victory lap. It didn't feel like one. It felt like watching someone I loved say, out loud, in a room full of strangers, the exact thing she'd spent a year insisting wasn't true. Gerald Voss, in his closing argument, made one final attempt to characterize the entire matter as a family disagreement rather than a legal one. Reasonable people, he said, can look at the same set of circumstances and reach different conclusions about what a dying man truly wanted. Judge Alvarez, in response, made a comment from the bench that Denise later told me she would remember for the rest of her career. Mr. Voss, the judge said, reasonable people don't need a notary's log timestamped at 2:40 in the afternoon to explain why they scheduled a signing 5 days after a documented note about afternoon confusion. This court isn't being asked to referee a family disagreement. It's being asked whether a legal document meets a legal standard. I intend to answer that question on the law, not on anyone's account of Mr. Callahan's character. Judge Alvarez took the matter under advisement and issued her written ruling 6 weeks later, on February 28, 2024. The ruling ran to 11 pages. The ruling found, based on the totality of the evidence, that the November 14, 2022 will was the product of undue influence exercised by Wade Callahan during a documented period of Frank Callahan's diminished cognitive capacity and was therefore invalid. The court further found that the April 3, 2014 will, having never been validly revoked, constituted Frank Callahan's true and final testamentary intent and ordered it admitted to probate. Under its terms, the trust originally established from my grandmother's farm proceeds, valued per the estate's final accounting at $1,187,112, passed to me, free and clear, exactly as my father had written it a decade earlier. In a lawyer's office neither Wade nor my mother had ever thought to ask about, until it was far too late to make it disappear. Denise called me the afternoon the ruling arrived. I was standing in my classroom during my planning period, grading spelling tests, when my phone buzzed with her name on the screen. I remember sitting down hard in a child-sized chair meant for a 9-year-old, the phone pressed to my ear, listening to her read the key findings aloud in the same steady, procedural voice she'd used throughout the entire case, and thinking, absurdly, that I should be crying, and instead just feeling a kind of quiet, bone-deep stillness. The particular exhaustion of a fight finally actually being over. I called Marcus next, and then, after a long pause standing alone in that empty classroom, I called Harold Whitcomb, because it felt important that the man who had kept a decade-old promise safe in his basement should be the first to know it had finally counted for something. Wade did not contact me after the ruling. Gerald Voss's office confirmed, through Denise, that the estate would comply with the court's order and would not appeal. A decision I understood later had been influenced heavily by the fact that an appeal would have required Wade to relitigate the undue influence findings. With Russ Delgado's testimony about the November 14th signing already on the record, and with an 11-page written ruling that left very little room for a higher court to see the matter differently, my mother sent me a single email, 4 days after the ruling, 3 sentences long. I know you think this makes things right. I don't know if I'll ever fully agree with the court's version of what happened. I hope someday we can find a way back to something. I read it several times before I answered. I still don't know if I fully believe the second sentence was honest, but I've decided, for my own sake, not to spend more energy litigating my mother's internal beliefs than I already spent litigating the actual document. I want to be plain about the outcome because I think stories like this one owe their audience clarity rather than melodrama. The court's order was not a moral judgment on my family. It was a legal finding that one document was invalid due to undue influence exercised during a period of documented cognitive impairment, and that another document, properly executed 9 years earlier and never revoked, controlled the disposition of a specific trust. The business, Callahan Precision Tool and Die, its equipment, its real property, its ongoing contracts, remained entirely Wade's, exactly as it always would have, in every version of my father's estate planning going back to 2014. I never contested that, and I want to be clear, I never wanted to. My fight was never about the shop. It was about a promise my father made me, repeated for 15 years, and about refusing to let that promise be rewritten by people who had more access to him in his final months than I did. The trust, once probate formally closed in June 2024, was transferred into my name in full. 187,400 held across the diversified investment account and the small rental property portfolio my father had built with its early returns. I did not spend it the way people picture inheritance money being spent. Marcus and I paid off our mortgage. We rebuilt the emergency fund we drained fighting for it. We set aside a significant portion for our son's education. I kept teaching. I still teach 4th grade, 3 days a week now instead of 5. A schedule adjustment I could only afford because of a fight I never wanted to have in the first place. My relationship with my mother remains, as of this recording, unresolved in any tidy sense. We speak occasionally, a phone call every month or two, careful and somewhat formal, neither of us quite willing to revisit the hearing directly. She has never apologized in the way I once imagined an apology might sound. What I've settled for instead is something closer to an uneasy truce, built on the understanding that we will likely never fully agree on what happened in that 6-week window between my father's Christmas conversation and the November signing, but that we can still, carefully, remain part of each other's lives. She did come to my son's 7th birthday party in April 2025, the first family gathering any of us had attended together since the ruling. I remember watching her sit at our kitchen table, the same table where she'd once told me the inheritance was never meant for me, now quietly helping my son open a present, and feeling something that wasn't quite forgiveness, but wasn't quite its absence either. Wade and I have not spoken since the ruling. I don't know if that will change. Some part of me hopes it will, eventually, once enough time has passed that neither of us needs to relitigate the past every time we're in the same room. Another part of me has made peace with the possibility that it won't, and that this, too, is simply a fact of what happened, rather than a wound I need to keep actively grieving. People sometimes ask me, when I tell this story, whether it felt like revenge, watching that ruling come down. It didn't, not really. Revenge implies wanting someone to lose. What I wanted from the very first phone call to Denise Okafor was simply for the truth, the actual, documented, notarized truth, to be allowed to exist in the same room as my family's version of events, and for someone with the authority to weigh both to be given the chance to do so. The truth happened to be worth $1.2 million. It would have mattered to me just as much if it hadn't been. What my father actually wanted was never really about the number. It was about being believed, and it turned out, in the end, that he'd made sure I would be, even from the other side of it, even years after the conversation where he told me it was mine. I think often now about Harold Whitcomb's basement, about a manila folder that sat untouched for nearly a decade, waiting for someone to finally ask the right question. There is a version of this story where none of that happens, where I simply make my peace with an inheritance that was never mine to question. I'm grateful, more than I can easily put into words, that I didn't let that version become the true one. Thank you for listening to my story. If it resonated with you, or reminded you of something in your own family, I'd love to hear about it in the comments below. Please like this video, subscribe for more stories like this one, and share it with anyone who might need to hear it today.